You what? You didn't have presenter? You should have presenter. You should have presenter.
Hi, welcome to the webinar. I'm sorry we're starting a little bit late today, but the good thing is we have 10 sessions, and if you register for more of the sessions, you'll get to learn everything we're learning today and then some. So welcome to our webinar, a very special webinar series. This is the first in a series of 10 webinars. This webinar is the introductory one, where we will be talking about being the best advocate for your student with special needs. So today we're going to talk about knowing your rights and the law so you can advocate effectively. I'm Cheryl Frischman, and I will be presenting this webinar, but I will be co-presenting with Julia Praska, another attorney in the office, for some of our other webinars. And please remember, we will be going through things relatively quickly, but each and every one of the slides that I'm going to present for you today really can be broken down. And one of the reasons why we decided to do this series in a series of 10 is so you will really understand special education advocacy and all of the topics we're going to talk about in depth. And you will be able to advocate effectively for a loved one, or if you're a professional, give advice, of course not legal advice, but give advice, and really understand what the laws are about. So I always start with this, if anyone's ever heard me speak before. I always want to talk about why the relationship between the parent and the school district is so adversarial. I have a child with special needs, and I remember going into the CPSC, Committee on Preschool and Special Education, which we'll talk about a bit, when he was 3 years old, ready for a fight. And I didn't get that because I was an attorney. I got that because of what I had seen on the internet and everything I've heard from everybody else that I have spoken to. So why is the relationship between the school district and the school so adversarial? I'm still having some technical difficulties. I can't pick the slide. And there's this. Let's see. All right. Sorry. Well, I'm just going to talk until someone helps me with the slides here. So, because there's barriers to building a cooperative relationship. When we Google what the relationship is like with the school district, this is what we get. Thank you, whoever switched that for me. The special education battlefield, the war to get services for children, the parents and the school districts are the soldiers, and us against them. And that is not a stance to go into a CSE or CPSE or a 504 meeting in. We need to be in a cooperative stance. That's why I feel comfortable doing this webinar if there's professionals listening in from the school district side or from the parent side, because we always have to start in a cooperative fashion. So next slide, if someone's controlling it for me, because, okay, there we go. So what are the barriers to a cooperative relationship? The first thing is parents and the district not understanding their legal obligations. And after this webinar, I think people, both parents and people that work for the school district, will understand that there are certain obligations. And while we understand as parents that there is a school budget, you know, and there's a tax cap, children with disabilities that qualify for special education are entitled to a free and appropriate public education. So it is free. So cost can't really be an issue. Also, that the school district has to, has to only provide, and we're going to talk about this, appropriate services. So as parents, we want the best, right? And the school district has to give us appropriate, which we'll discuss in more detail. Limited resources, like I said before, there is a budget out there and a tax cap, and it is expensive to educate our children. So the school district, even though they're not supposed to, of course, is going to have some financial constraints and try to fit a child into maybe a class that they currently have before looking outside, even if it isn't the most appropriate. But even on the flip side, as parents, we have limited resources. Trust me, when my son was little, it was recommended he get 60 to 70 hours of ABA a week. I couldn't afford that, so of course I'm looking for the school district to provide those services. There's also turf wars. We go into these meetings saying, this is my kid, and I know my kid more than anyone else. And who are you, school district, to tell me what my kid can have? On the other hand, the school district went to school. There are people sitting around that table, psychologists, speech pathologists, special education teachers, that went to school to really understand their subject area and are there to help. But sometimes we have turf wars. And the biggest barrier is coming to the table with preconceived or predetermined program or services. We really need to work cooperatively. So next slide, please. So how do we build a more cooperative relationship? All right, there we go. Understand that there is a mutual goal, okay, that the appropriate education of the child. The school district is not there for your student to go backwards, okay? The school district is there to help your child move forward, just like you want your child to move forward. There's a shared responsibility in the education of a child. So as much as I wanted to, when my child was young, say, go school district, take him and fix him, until I really brought home even what I had learned from the school district and brought it into my house, only then did I see the greatest impact on my son's education and him moving forward. Good communication. We need to talk about stuff, okay? We need to let the school district know that things aren't working when we know that things aren't working. We shouldn't wait till an annual review happens to say, hey, wait a minute, something's not working here. We have the opportunity anytime to do that, okay? And same thing goes for the school district, where if something's not working or they're thinking of changing placements, we hope that the district will let us know before we walk into that annual meeting and have ongoing communication back and forth throughout the school year. And both parents and the school district need to understand their legal rights and obligations under the law. So we may have a relationship with our school districts for up to 21 years, and we'll talk about that. So you don't want to start in an adversarial fashion, or it will be a more difficult road. Of course, I always recommend continuing in a cooperative fashion, but I'm sitting here because I have a job as an attorney, so you know that sometimes that does not work. But knowing the law and understanding rights and obligations will really help that cooperation build, so you don't have to get to the lawyer where it becomes more adversarial. And because we're running a little bit late today, I'm going to talk about the history and the overview of the laws very briefly. But today, we're going to specifically dive into Section 504 and the IDEA. Section 504 of the Rehabilitation Act and the IDEA, the Individuals with Disabilities Education Act. The ADA and No Child Left Behind and DASA are also statutes that deal with special education students, but No Child Left Behind and DASA actually are for all students. There should be a little star next to that blue that says these laws apply to all students, including students with disabilities. That's what that asterisk is for. The top three, Section 504, IDA, and ADA, only deal with people with disabilities. The No Child Left Behind and DASA only deal with all students in school, regardless of whether they have a disability or not. So very quickly, we have these rights because of a historic Supreme Court case in 1954, Brown versus Board of Education, where they said that you could not discriminate against people due to their race in school. In 1964, we had a Civil Rights Act that did not include discriminating against people with disabilities. It prohibited only discrimination on the basis of race, religion, ethnicity, national origin, and creed. Gender was added later. Not until 1973 did we get Section 504, which wasn't an affirmative, which didn't put an affirmative obligation on the school district to do anything, to provide special education services. What it did was saying you can't discriminate against students with disabilities. You have to let them at least through the door, okay? But they didn't really look at the quality of the education until we got to 1975, where we have the Education of All Handicapped Children Act, which is the predecessor to the IDEA, and with the Individuals with Disabilities Education Act that we have now. So if you think about it, we're still very, very young in our history, and the school district did not have an affirmative obligation until 1975 to actually provide appropriate services for special education students. And I just put this up there because this is an introductory webinar, because I want to really hit home how new this is, how there's parents that may live next door to us with adult children with disabilities that did not have the same access or services that we have today. But we need to remember, as parents and as school district personnel and people that help students with disabilities, that there's always cutbacks and that we really need to continue to advocate so we can keep those services that are available to children with disabilities. So the intent of the disability laws in schools are the following: that individuals with disabilities have the same rights to access, okay? We need to have that wheelchair ramp in place. We can't have a child in a wheelchair that doesn't have, that has to go up steps, okay? We need access. Equal opportunity, okay, not just equal treatment. It gives a legal remedy for those experiencing discrimination. Private entities may be exempt, and when we talk about college specifically in this webinar series, we will talk about what happens when you go to a private university. And you must provide FAPE, which is a free and appropriate public education. They mean different things for different students. For a student that has a 504 plan or a student that has an IEP, which we'll define later, but they must provide FAPE, a free and appropriate public education. So the first law that we're going to dive into today is the IDEA. Okay? The IDEA, the Individuals with Education Act, which some refer to as the Individual Disability Education Improvement Act. I just took out the, the I because I like to call it IDEA. The Individuals with Disabilities Education Act, and is a federal law. That means it's the law of the land. That means that whether we are in Hawaii, or if we're in Alaska, or if we're in New York, where I am here today, that we have this school district or those laws apply anywhere you are in the country. Okay, so it's a federal law. So the purpose of the IDEA is to ensure, and I'm going to read right from the law, to ensure that all children with disabilities have available to them a free, appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. And that little purpose, that's one large sentence, is really everything that we're going to talk about in terms of the IEP, the CSE meeting, services, because everything revolves around the unique child and the appropriateness of the program. And also, just as an aside, further education, as you see in the second to last line of the slide, was just added in 2004. So this, again, because this law just started in 1975, excuse me, it's continually evolving. And the further education was added because we do need to make sure that students with disabilities that go on to college are ready and prepared for that. And so that's something that we'll talk about in depth when we talk about transition and also when we talk about college and life after school. So the IDEA is the federal law, and the Part 200 is the New York state law. Like I said before, the federal law applies to all states. So New York, it cannot take away anything that the federal law gives us, but it can give us more. So as a parent of a child with disabilities in New York State, if you're listening from New York State, Part 200 is really where you want to go first. And at the end of this presentation, I will give you a great website that you can access Part 200. Just make sure you don't hit print. You know, when you get to it, because it's very long, but every parent of a child with disabilities really should get through the regulations on Part 200 and really understand, so they don't have to pick up the phone and call a lawyer when they're not getting their meeting in a timely fashion. They would have read Part 200. Also, New York gives us more in a variety of different places in terms of who needs to be on the CSE team, the Committee on Special Education team, what services are provided for a child that has a classification of autism, and also what age transition should start for a child with a disability. So you really should look at Part 200. But again, New York, it can't take away anything that the IDEA gives us, but can give us more. So it's important to understand what your specific state law is and not run to some general website that talks about all different states, because what's really going to help you in terms of advocating is understanding your state's rules and regulations. So who is entitled to services under the IDEA? And as the definition expressed, a child with a disability is the only child that's entitled to special education. So that's actually a two-tier test, and it's important that we understand that. So there are the first part of the test is the child has to have a disability, basically. So number one is the child has to fit into one of 13 classifications in order to get services. So the child has to basically have a disability. We'll speak a little bit when we talk about the IEP and the meeting itself about, you know, those classifications and what they mean. But your child has to be disabled, basically. But the second part of the definition is who, that child with a disability, by reason of that disability, needs special education and related services. That's the part that sometimes gets confusing. So if a child with all the bells and whistles put in place, let's just say you have a child with ADHD. I have a child with ADHD. I have a child with autism and then a child with ADHD as well. And that child, my daughter, can learn like everyone else as long as she's given certain accommodations like extra time, preferential seating. She's right now paperless. But the curriculum in no way has to be modified for her to learn. She doesn't need special education services. She just needs accommodations. She does not qualify as a student with a disability under the IDEA that's entitled to services. So sometimes that's very, very confusing, because just because you have a disability, as long as the curriculum in some way does not have to be modified in order for you to learn, then you would not qualify for services under the IDEA. And we will talk about that in more detail in a later webinar. So what if you are a child who only, and I'm saying only because we only have a disability, okay, but you only meet part 1 of that test, which is a child with a disability. You are covered under Section 504. Okay, and Section 504 is a civil rights law that protects all people with disabilities. But 504 provides fewer protections than the IDEA. So I just want to quickly go through the difference between the type of services that you're going to see in a 504 plan versus the type of services that you would see in an IEP. Now, an IEP can also have accommodations, but a 504 plan will only have accommodations. So, for instance, in a 504 plan, you may have or provide, there must be a provision for equal access to learning. It provides a student with equal opportunity, are based on individual strengths and weaknesses, can vary in intensity and degree, but does not substantially change instructional level or content, okay? So that's the really key thing about a 504 plan. Whereas if there's an actual modification, there may be a change in what the student is expected to learn. There may be a change in instructional level or benchmarks, a change in the number of key concepts mastered within a benchmark or unit of study, or a change in content or curriculum. You can't get that in a 504 plan. A child needs to require some sort of modification in order to qualify for services under the IDEA and get an IEP. So does every student with a disability get a plan of some sort, a 504 plan or an IEP? Absolutely not, okay? If you do not require services, okay, if you can learn but for your disability without accommodations, you don't necessarily get a plan. Okay. However, you are protected from discrimination from 504. Okay. So all students with disabilities, regardless of whether they have a 504 plan or have a IEP, are protected from discrimination. So here's a visual just so you see. 504 students is the big circle, and it actually should be a much bigger circle. And IDEA students are actually a tiny little circle. So everyone's protected if they have a disability under 504. You're protected from discrimination. But, and if you have services under the IDEA and you have an IEP and you're getting special education, you're automatically protected under 504 from being discriminated, but it's not the other way around, okay? So that visual hopefully will help you understand. So what does the school district actually have to provide? Again, we're going to break this down so much in future webinars, okay? So if you're interested only in 504, we're going to have a whole webinar on that, okay? But basically, the 504, in order to provide a free, appropriate public education, the school district needs to provide education comparable to the education provided to non-disabled students. That's their obligation, okay, to level the playing field for that student with a 504. But under the IDEA, the school district has more obligations. They have to provide special education and related services that are provided in an individualized education program designed to meet the unique needs of a child with a disability, meet state standards, and are provided at public expense. So we're going to talk a little bit about the IEP and then more in detail when we do an entire webinar on the IEP. The district has an affirmative obligation if you are a child who qualifies under the IDEA to get an IEP, an individualized education program, a plan together. It's got to meet state standards. That means that the child needs to move forward. You know, they can't be left behind just because they have a disability. We have to base it on state standards, and it's got to be free. But the big thing, okay, that we need to understand is that these services do not have to be the best. They have to be appropriate. Okay, and over again, I have parents say, well, what is appropriate? Now, if there was a definition, okay, of what it was appropriate, I wouldn't be sitting here today with the job in special education advocacy, because we absolutely, this is what we argue about, parents versus school district. What is appropriate? The school district may think that one program is appropriate, and the parent may think another program is appropriate. And it's got to be based on the unique needs of the child. So I use, if you've heard me speak before, you know this analogy, but I usually use a car analogy when I'm talking about appropriateness to explain it to parents about what the obligations are of a public school to provide an appropriate education. So here's my, you know, very old car analogy. So I would love to be driving a Ferrari, a red one. It's hot. It's the best, in my opinion. And I think I would look great in that car, and I think it's the fastest and would get me to school and to work the most better than any other car possible. Does the school district have to give me that Ferrari? Absolutely not. The school district has to give me the Volvo, okay, which I drive now, which is great. It's a nice car. Or a Chevrolet, okay, a safe car, a nice car, but not a Ferrari, okay? It's a safe car. It will get me back and forth to school and gets me back and forth to work. It's certainly not as sexy, and it's certainly not the best. And that's what's so difficult for parents to really understand, is that the school district is a public school. They don't have to provide the best to the general ed students. They have to provide a public education, and it's got to be appropriate. It's got to be the Volvo. It's got to be, my colleague Marion would say, the Nissan, okay? But it does not have to be the Ferrari, and that's very important for parents to understand when they come into school districts with recommendations from doctor after doctor saying you must do this, you must do this, you must do this. The school district may have another definition of what is appropriate, even though you've paid a doctor to tell you what the best is, and that's really difficult. But where parents have really a hand up in this is it's got to be appropriate, but it's got to be unique, okay? So even though it's got to be that Volvo or that Nissan, it's got to be one that fits me, and it's got to be one that fits my child. And just because you have a special education program at a school, it doesn't necessarily fit. It may not necessarily fit the unique needs of my child. So a district may argue appropriate, we have appropriate, we have appropriate, and a parent may say this is may be appropriate for another child, but it's not appropriate for the unique needs of my child. And we'll talk in more detail about that and very in-depth about that in future webinars. But it's a very, very hard concept for people to understand appropriateness. So in the 504 and IEP process, there's a process, okay? They all start with referral, evaluation, eligibility determination, developing some sort of plan or an IEP development, and then periodic reevaluation. So for 504, the parent or school can make that referral. However, the school district must also have reason to believe that the child is in need of services. Okay, so if you make a referral under 504 and the school district says, you know, I don't see it, they can actually not have to evaluate a student. Okay, so just understand that usually doesn't happen that way if you have a cooperative relationship with your school district. But this key is that the school district must also suspect that there's a problem. If a child's showing serious disorganization, the school district probably, for example, the school district will suspect that there's a problem. For the IDEA to refer to the Committee on Special Education, the parent or the school can make that referral. So the next webinar that we're going to be doing next month is all about understanding evaluations. We are going to talk about what they are, when we do it, who needs to do it. Do you understand them? What you need to ask about them, and your right as a parent to independent evaluations. Evaluations, data, testing, that is what drives the program, okay, especially for an IEP. So we need to, as parents, understand the lingo. We need to understand what an age equivalent means, a grade equivalent means, what a standard deviation is, a SK9, a T-score, a Z-score. Unless we understand that, how can we be sitting at the table with the school district? Because you keep, as a parent, you know there's something wrong with your child, let's say, and the district keeps saying, well, you know, the testing's all coming back that the child is average. You know, if you don't understand that testing, that may be true, and it probably is true that the child's coming up average. But if you're an educated parent, hopefully after the next webinar, and you'll be more educated in terms of how to read evaluations, when that district says your child's average, and you know they're not, you will find in those evaluations, maybe, for example, subtest scatter, okay, that there's a subtest that shows that a child may be, and I'm exaggerating, you know, at a 0% level in one area, but 100% is functioning at 100% in another area. So of course they're going to come up average, but what about that 0%? Okay, and that the child is compensating. And unless you can really read that subtest scatter and understand what those scores mean, you really cannot be an effective advocate for your child. So it is our job as parents. It's not something that I went to law school for. It's something that I had to learn in order to be an effective advocate for my child. And we do here at Littman Krooks, when we advocate for our students, we're reading those testing. We go straight to the data because the data is what's going to drive your services. So some things just to keep in mind, again, we're going to talk for a whole hour about evaluations next time, is that there really is no diagnosis from a physician required. However, I do recommend that if you go to a medical doctor, especially if you're looking for a 504 plan, that you have a diagnosis. All evaluations must be done at no cost to the student, okay? So if the district says, hey, go get your own evaluations, you can't do that. You may not be happy with what comes back, or you may want a better set of evaluations, and sometimes parents want that and they go out on their own. But the core evaluations must be done at no cost to the student. The school just is not doing you a favor in evaluating and providing a child with a disability with appropriate services. The school districts are required, okay, under law to do this regardless of the cost. So we need to understand that we're not getting handouts here. Our children are entitled to these evaluations and those services. So quickly for 504, now we're going to break out a little bit just to give you a general overview between the difference between 504 and the IDEA. In terms of the 504 eligibility team, there's really no requirement in the law of who needs to be there, whereas under the IDEA and Part 200, there are absolute requirements. You just have to have a group of people who are knowledgeable about the child, that understand the meaning of the data, that understand placement options, the least restrictive environment, and understand what they can and cannot do for the child. There's no maximum number under the team. Usually buildings have an appointed chair, and it's not the director of special education. 504 is a building plan. It's an accommodation plan for that building. So typically, for instance, there's a 504 chair for the high school, or then there's a different one for the middle school, and there's a different one for the elementary school. For the IDEA, we have a committee that's required under the law. And we're going to speak specifically about that big meeting and who is required to be there. So just an overview, just to understand what we're talking about when we talk about CSE. It's a committee of special education that is from age 5 to 21, so kindergarten until 21. Now, I guess I need to actually tell you that 21 is not for all students. 21 is the max. So if your child graduates at 18 and gets a high school diploma, the IDEA no longer applies. So it's 21 or 18, or graduation, excuse me, whichever comes sooner. Very, very important. So the Committee on Special Education is ages 3 to 5. And who is on the CSE and CPSE committee? This is something we're going to go over in depth when we talk about the meeting at that webinar. And there are certain requirements in New York. So in terms of eligibility for 504, and again, whole webinar on 504, they need to look at that the child has a disability, a physical or mental impairment, that poses a substantial limitation on a major life activity. Okay, that's the 3 prongs we've got to look at when we're evaluating whether a child is allowed to get services under Section 504. If the child just has the physical or mental impairment, that doesn't mean that they're going to get services. That physical or mental impairment typically would affect their learning, which is a major life activity, and that means that the school district needs to provide an accommodation plan. So a 504 plan is just that. It's a written, it doesn't have to be written, but it is typically plan of accommodations for the student. It's not special education. So these accommodations need to be reasonable, and there's absolutely no funding from the state or the federal government, and it has to be free. And courts have found that the reasonableness of a school's obligation under Section 504 are not limitless. So if you have a child that's allergic to everything in the world, and I've seen this before, you know, even the cleaning solutions that are used, and the walls, the carpeting, if the windows are open, they can't learn. If the entire school has to be turned upside down in order for this child to learn, that probably would be considered unreasonable, and the district would say, look, we don't have to do this. It's not limitless here what we have to do for this child. It's unreasonable to expect that we're going to change everything, the fields, the carpeting, all our cleaning supplies, leave all the windows open, you know, for that child, whatever it may be, and maybe we would educate that student at home. So these are just some common accommodations that we see in an accommodation plan. And again, we have an entire webinar on this. On just, again, I just want you to see that none of this is changing the curriculum in any way. But again, please tune into our 504 webinar, and we will go through that in depth. So for 504, we're typically placing a child in the general education. That's the least restrictive environment. We're not looking at any sort of out-of-district placement or smaller class size. In terms of monitoring a Section 504 plan, parents really have to be on top of this a little bit more than what they would probably have to be if the child had an IEP, because it's difficult. They don't have the same obligations to monitor like the IDEA provides for a student with a disability that has an IEP. So I actually feel with my daughter who has an 504 plan that I spend more time kind of helping the school understand her accommodations and making sure they happen than I do my son who has severe autism, because his services are mandated in a document. They know what they need to do, and it's more difficult sometimes in a 504 plan. So we need, as parents, to stay on top of that. And remember also that it's building specific. So if you're moving from the middle school to the high school, you're going to have a new plan. Okay. So we're not going to talk in depth because we are running late on time about the grievance procedure, but it's different than what you would get for a special education action. You're looking at the student handbook to find out what the procedure is, and we're dealing with the Office of Civil Rights ultimately because this is a civil rights statute, very different than special education. So now we're going to go speak about the IEP. Remember, we have an entire hour where we're going to be talking about the IEP because the individualized education program is what you're getting as a student with a disability. So you've already met that two-tier test. You're a student with a disability who is entitled to special education services. You've had your evaluations. They show that the child needs some modification in order to learn, and the school district needs to put together this program, this written program, the IEP, and this is your contract with the district. Now, it isn't a legal contract. Well, I believe it's a legal contract, but you're not going to see anywhere that the IEP is a legal contract. But why it's really important to think about it as a contract, if it's not in there, it doesn't have to happen, okay? And this is the document, the written document, where the school district commits certain resources to your particular child, okay? So it is a contract, and it's really important to think about it that way. So if your IEP looks the same every single year or hasn't changed, it's probably not a good contract. Okay, so like I said, an individualized education program, it's a written document different than the 504, and we're going to talk briefly about what it's got to have in it. But again, we have an entire session on the IEP document and developing a good IEP. But basically, I want you to know it's a written document that encompasses all the resources that the school district's going to commit to your child and what your child needs in order to make progress and what your child needs to work on from year to year. So the first part of the IEP, after we have the identifying information, are the present levels of performance. Now, we as parents always go to the end part of the IEP, the part that says, okay, great, I got the right placement and I got the right services, but we really need the first two parts, which are much more important than really the end result, because we have to understand the evaluations and the data. That data drives the present levels of performance. So if you look at your IEP, it's a pre-printed form, so it's on everyone's IEP, you'll have 4 present levels of performance. It's going to look at your students and their performance in 4 areas: academic, social, physical development, and management, and how that disability affects that child being and taking advantage of the general education curriculum. So all of that data needs to be spoken about in the present levels of performance. And when you look at those present levels of performance, they really need to look like your child. So the most important part of the IEP after the present levels of performance are the goals. The goals are what the school district needs to work on, okay? That's it, all right? So there needs to be one annual goal for each need identified, okay? We don't need 100 goals, okay? But the goals need to be meaningful, and they need to be associated with a need. They need to change from year to year, okay? And they need to be appropriate and meaningful. And when we go over the IEP document, I'm going to speak to you specifically about how to create goals and how goals are measured, but they're really important. So I'm just going to give you a very quick exaggerated example of why the goals are important. So a parent comes into my office and says, oh, program's not working, I want an out-of-district placement, I want to sue my school district. Say, why? You know, is it not working? And they say, well, you know, my child, Adam, he's tracing the letter A over and over and over again. He learned that 3 years ago. What kind of appropriate program is this if he's still doing this tracing of the letter A? So you look at Adam's IEP and you open it up to the goals, and wouldn't you know it, goal number 1 is child will trace the letter A. So what is the school district doing? Exactly what you, contracted with them to do. Okay, so the goals were developed collaboratively. They hadn't changed. And we need to go back and not sue the district, but have a program review so we can have good goals, meaningful goals. And they're so important. So in this case, you know, mom or dad may have not been a meaningful participant in the goals. They never read the document. But the school district, if they're doing what they need to be doing in that piece of paper, may not be, you know, technically, you know, they're doing what you contracted with them to do. So goals are so important. Understanding evaluations, determining what a child's present level performance are, and creating goals, because the goals are going to drive, okay, the goals are going to drive the special education program, okay, which are the resources we're going to commit. So we don't say, oh, we have this class in the district, let's just put the child in there and create goals around that. We create goals, and then we look and see what we need to provide for that child, and if the school district can in district provide that. So the goals drive the special education program. Again, we're going to talk about the IEP and what is required in detail, but they can include special classes, resource rooms, you know, travel, training, home instruction, special teachers, etc. And related services as well. So in addition to special education services, does the child need speech or OT or PT to achieve their goals? Okay. Again, we're not going the opposite way. Okay, this is a district that we only provide 2 speeches a week for every child. Well, if the child's goals necessitate more than 2 speeches a week, district's got to provide more than 2 speeches a week. So the goals are going to drive the special education and the related services, program modifications and accommodations, which are what the entire 504 plan looks at. So even though we have a child with an IEP that may get all these serve special education and related services, do they need some of those same accommodations like preferential seating, extra set of textbook, et cetera, extra time on tests? Very important, the school district must have a scientific research-based methodology, but it doesn't necessarily have to be the methodology you choose. And we see that a lot, and we're going to talk about that in specifics when we talk about the development of an IEP. I have parents of children with autism that come in all the time and say, you know, I'm coming from an ABA, Applied Behavior Analysis preschool. I, you know, want to continue that, and maybe their school district provides a TEACH methodology, which is another methodology for a student that has been proven scientifically to help students with autism. So can a district do that, switch a methodology that's worked in preschool to another methodology? Absolutely, as long as it's appropriate, though. So we start looking at that appropriateness and the uniqueness. You know, we also see with speech, parents wanting prompt therapy. Methodology is not something we can choose as long as it's, but you have to make sure it's a scientific research-based instructional practice. And we'll talk about that in more detail again when we do the IEP. Does the child need assistive technology? This needs to be reviewed for all children. Assistive technology is not a speaking device or a computer, while it is, but it's also any piece of equipment or product or system, whether acquired commercially or off the shelf. PEX pictures, a pencil grip, a seat cushion that helps with positioning. Those are all things that need to be in the IEP and are considered assistive technology. If they're not in the IEP, they don't have to happen. Now, I, like anybody else, you know, a school district may say, oh, come on, you know we're going to do that. But what happens if the teacher changes? What happens if the administration changes? Unless we have it in the document, we don't know, the teacher's not going to know what to do for the child. Now, transition starts in New York State when a child is 15, and we have, I think, 3 webinars specifically talking about transition. Transition in terms of planning, what transition is, and transition for students that are going to college, and transition for students that may not be going to college. So that's also part of the IEP. When the child is turning 15, we need to talk about what it's going to take. Basically, that's what all those words are, to get that child to move successfully from school to post-school. this beautiful, very confusing visual here is we need to also know talk about graduation requirements. Again, we have an entire webinar on this, an entire hour. Basically, your child with a disability, can leave school or exit school two different ways. One is with a high school diploma and the other is a credential. And we will be discussing this one slide for an entire hour. This is not going to be the only visual, but you will know what those different options are for a student with a disability to exit, whether it be a high school diploma or a credential. We also need to look at summer services when we're examining the IEP. Summer services can only occur if there's substantial regression and are only to maintain that student, not to move that student forward over the summer. Now, after we've considered all of that, we're going to look at that special education student and say, where do we place them? In what environment? In what class? In what school? Because the school district needs to provide the services for the child in the least restrictive environment, which means to the maximum extent possible, we need to educate students alongside their non-disabled peers. So in the situation of, let's say there's a school district that has one self-contained class there, instead of saying from the get-go, okay, that child is going to that class and let's build the program around the class. The difference, and what I'm going to take you through, what Julie and I will take you through when we speak about the IEP and the CSE meeting at those webinars is it's different. We're not building services around a class. We're building services around a student, around the student's evaluations, their present levels of performance, the goals that they have, the services they require, the related services they require, the assistive technology they require, and the transition services they require. And then we look around and we say, can we do it in this class? And if not, then we need to look elsewhere or bring in more resources for that child. Now, I am running out of time, so we're not going to go into detail about this visual here. Remember, we're going to have an entire 504 webinar, and we're going to break down the IDA into itty-bitty pieces, so you'll have an understanding of all of this. But really what I want to hit home is, and which we actually spoke about, is that the IDA is to help as an affirmative obligation for a school district to provide special education students, and Section 504 is a civil rights act that levels the playing field. They're very, very different, okay? And we talked a little bit about that when we talked about the two separate laws, but we again are going to dig much deeper into it in future webinars. And again, we talked all about all of this today, and we will dig very deeply into each of these at the later webinars. So, in terms of preparing for a student to preparing for the meeting, we do not want to wait to develop the IEP or the 504 plan until the meeting. We're going to talk about that as well. We want to review all evaluations and progress reports with team members before the meeting. If the district gives you your reports on the day of the meeting, or I'd say if you don't have it a week before the meeting, you don't meet, because you can't be a meaningful participant of that committee unless you have that information before the meeting and you develop goals and accommodations collaboratively. You have all sorts of roles during your meeting: a parent, you're a listener, a questioner, an active team member, a creative thinker, and an advocate. If you don't feel comfortable with any of the above roles, then you may want to bring someone with you. I'm not saying bring an advocate or an attorney to your meeting, not at all. I'm saying bring a friend, a grandparent, your spouse if they don't typically come. Maybe they're a better speaker, and you're better at taking notes. While I can attend anybody's IEP meeting or 504 meeting and not have a problem and be very eloquent and wonderful, as soon as I walk into any of my children's meetings and they ask the first question, how you doing? I start crying, because it's my kid. And we all feel that way about our kid. And I need help in presenting the materials because this is a business meeting, and as a parent, it gets very, very emotional. And we'll talk about tips in terms of preparing for the meeting when we talk about meeting. You know, after the meeting, you want to thank everyone. If you didn't come to a resolution, we want to have another meeting possibly and make a date for that, and if possible to see a draft before it's finalized. If you don't agree under the IDEA with an IEP, again, you know, maybe come in with more data and have another meeting first, but there is a system, which we're not going to talk about in depth today, to sue your district, I guess, in lack of a better word, into providing appropriate services. You start at the administrative level, which is a hearing, then it can be appealed to a state review, and you don't get to court until those two administrative steps happen first. When you file a due process hearing, you get to stay put, which means you remain in your current placement or the last agreed upon placement. This doesn't typically apply for preschool students. You can't stay in preschool, but there is, if a district, for instance, trying to move you to another program or bring you back into district and you file the due process saying you want to stay, you need to be able to stay put in that current placement. There's also mediation that's available in New York State. We really haven't used it as much, but we're starting to a little bit more, and we'll talk about that when we talk about the CSE meeting and the IEP development in later webinars. This is the website that I'd like you all to go to know your rights and to start being an educated consumer. Just like the store closed, but I used to love the Sims commercial that said, you know, that Cy Sims used to say, you know, an educated consumer is our best customer. So we're going to start with the Office of Special Education. You're going to look at Part 200, and you're going to start taking a look at some of the things on that site, and then when we get to the next part of the next webinars, we're going to start really digging into each of these topics in more depth. I have two questions that I'm going to answer from listeners, and then we're going to say goodbye for this webinar, and please tune in for the evaluation webinar because it'll really help you understand the testing and understand evaluations. So my first question is, who decides what's appropriate and not appropriate, the parent or the school district? Neither. The committee decides. That committee on special education. You decide together. The parent is a member of that committee. Okay? The chair is not the dictator of that committee, the whole committee. And we're going to talk about that in depth when we talk about that big meeting. You don't decide as a parent what's best for your child. The school district unilaterally doesn't decide. We decide as a committee. Okay? So who decides what's appropriate is the committee. We're going to look at the testing. We're going to look at the child's needs and present levels of performance, and we're going to come up together with an appropriate program. Sometimes the program looks different. You as a parent may think something else would work for the child based on the testing and their present levels of performance, and the school district thinks something else. But in an ideal world, we all work together to develop the appropriate program. Neither one decides. The second question is, does Section 504 and the IDEA apply to special needs children without a diagnosis, children with severe developmental delays but do not have given an official diagnosis? Yes. You don't need an official diagnosis to get services. You need just to be classified. There is a kind of a catch-all, other health impaired or multiple disabilities. That is that catch-all for students with a with a disability that maybe cannot be diagnosed. For 504, in order to be protected, if a child has a severe developmental disability without a name, of course they would still be protected even if they didn't have a a diagnosis that you know, like autism or something like that, if they have something that's holding them back, some neurological or emotional disorder that's holding them back from learning, whether or not it has a name, it would apply to them, both statutes. So those are the two questions that I have that I'm answering right now. I hope you enjoyed this webinar. I'm sorry we started late and had some technical difficulties, but I hope that you will join us for, and I've piqued your interest and given you a little taste of what we're going to learn in the upcoming webinars. The next one, I don't have the date in front of me, but it's in October, another lunchtime webinar where we're going to talk only about evaluations. And it'll take you through how to read those testings, how to understand the data, so you can be a better advocate for a child with special needs. On behalf of Littman Krooks, I want to thank you for attending today and have a wonderful day. Thank you.